Good morning, sir. Can you see and hear me?
Yes, I can. Thank you. Before you begin examining the witness, Mr. Beard, I'd just like to let everyone know, if they're not aware of it already, that the program for this week will go ahead as has been scheduled, i.e. that is, it will go ahead with the witnesses which are named on our website. And I'll try and give an update dealing with the period between the end of this week and Christmas, tomorrow or Friday at the latest. All right?
Thank you very much, sir. May I call Warwick Tatford?
Yeah.
Repeat after me. I swear by Almighty God.
I swear by Almighty God
That the evidence I shall give.
that the evidence I shall give
Shall be the truth.
shall be the truth,
The whole truth.
the whole truth,
And nothing but the truth.
and nothing but the truth.
Nothing. Thank you.
Thank you.
Make yourself comfortable.
Thank you.
Good morning, Mr. Tatford. My name is Jason Beer, and as you know, I ask questions on behalf of the inquiry. Can you tell us your full name, please?
Warwick Henry Patrick Tatford.
Thank you very much for coming to the inquiry to give evidence today, and thank you very much for the provision of a substantial witness statement to the inquiry. Can we look at that witness statement, please?
Yes,
It should be in the bundle in front of you.
I have it.
A1.
I have it, thank you.
Excluding the index, it's 57 pages in length and dated the 25th of October 2023. Can you turn to page 57, please?
Yes,
Is that your signature?
it is, yes.
And are the contents of that witness statement true to the best of your knowledge and belief?
Yes.
For the transcript, it needn't be displayed. The URN is WITN 0961 0100. A copy of that witness statement is going to be uploaded to the inquiry's website. And I'm not going to ask you questions about every aspect of it. Do you understand?
Thank you.
Could I start, please, with a short number of questions about your professional background? I think you were called to the bar in 1993, is that
Yes.
right? You became a tenant in Chambers in 1994.
Yes,
At your present Chambers, albeit it's changed name twice since then, is that right?
that's right, yes.
And you've practiced almost exclusively in the field of criminal law, both prosecuting and defending.
Yes.
Most of my questions today are going to concern the case of Seema Misra. Can I start at the end, as it were, and go to page 56 of your witness statement? I wonder whether that can be displayed on the screen, please. Page 56. And the bottom half of the page, please. And if we scroll down, thank you. This is the concluding paragraph of your statement. And 6 or so lines from the bottom, you say, quote, "I am proud of my role as a barrister in the criminal justice system and am extremely sorry that I played an unwitting role in Seema Misra and Carl Page having unfair trials. I'm particularly conscious that in Mrs. Misra's case, I was prosecution counsel at the head of a difficult disclosure exercise that failed." And then over the page, "Over the years, as I have watched and tried to learn from all the Horizon cases, I've thought repeatedly about whether there was something different I could have done, whether I should have asked more or different questions, whether I should have insisted on an independent expert. I cannot see how Professor McLachlan could have worked without considerable assistance from Fujitsu and someone like Gareth Jenkins, but perhaps there should have been the extra precaution of an independent expert on the prosecution side." And then I won't read the rest. And so you tell us in that statement there, unlike a number of other witnesses who have sat in the same witness box as you, that you are extremely sorry that you played a part in Mrs. Misra and Mr. Page having unfair trials.
Yes, I'd like to offer my unreserved apologies to both of them. I know Mrs. Misra, I can see her. and I'm very sorry. I don't know if Mr. Page is here. I might offer my apologies to him. Sorry, I find this rather difficult. It's not actually about me, but I do feel ashamed about what's happened, and the best I can do is try and help the inquiry and try and learn a bit myself. But that's enough about me. It's much more important to answer the questions, but I'm sorry. I feel ashamed that I was part of this, but I want to try and help if I can.
Thank you very much. That can come down. The inquiry has heard evidence that the Post Office saw the Seema Misra case as a test case to deter sub-postmasters for blaming the Horizon system for alleged shortfalls or advancing Horizon integrity issues as defences when they were prosecuted. Did you get that understanding when you were prosecuting this case, that it was seen as a test case with a deterrent purpose?
No, I knew that it was an important case, and important for all parties. But I've seen reference to test cases. It seems to me that a criminal trial can't ever be a test case because the case is decided on that individual case and everything is different. But it was a very important case, and the Post Office Limited clearly wanted to do whatever they can to try, they could to give a full evidential picture of Horizon. It may be that they, and indeed me, that I was, we hadn't realised the problems. But it seemed to me that it was an exercise not in shying away from the challenge. It wasn't a test case. I do appreciate that after the trial, there was an announcement made by my instructing solicitor. For what it's worth, and it's only my opinion, I thought that was unwise. Because my view wasn't that this was a test case, it was an important case. One of the ironies of the case is that when it began, many of those involved in the Post Office would have, I think, would have accepted pleas to false accounting. One of the ironies is I think I was the one who put my foot down initially and suggested that we should proceed on the theft trial. So certainly at that stage it wasn't in any kind of test case. It became important, but I think test case, I wouldn't agree with that title. But it was still it was clearly very important to the Post Office.
Why was it important? In what respect was it important to the Post Office?
Well, because the Horizon system was a system used throughout the business and throughout all the post offices up and down the land. And it was important that that worked, not only in terms of criminal investigations, but for the general public. It's essential that it works.
So if we take out of the question the legal language of test case,
yes,
would you agree that it was seen by the Post Office as an important and significant case?
Yes.
It was, and it was important and significant because it was necessary to demonstrate convincingly that there were no problems with Horizon.
Yes, I think I would agree with that. I do think that it was treated as an individual case, but there was a significant challenge to Horizon, and the Post Office did think that had to be met, and that there was a wider public interest in that being met.
And how did that importance or significance manifest itself in the conduct of the case?
In a strange way, it didn't. There was just a feeling of a lot of pressure throughout the case. At an early stage, before Gareth Jenkins was instructed, there was a lot of pressure because of what we considered, rightly or wrongly, to be very wide-ranging and potentially, to an extent, irrelevant disclosure requests. There was a lot of pressure trying to deal with that situation. And then once Mr. Jenkins and Professor McLaughlin were involved, and as I saw it, cooperating together, it was seen, I think, as important by both sides that they should work together to try and establish whether the problems that were alleged against Horizon, whether they existed or not. That was an important issue. In a way, though, it was a slightly strange case to choose because there were lots of complexities to it. There was the complexities of the initial defence statement and so forth. In a way, I suppose if the Post Office wanted to choose a test case, they might have chosen a case that was more straightforwardly dependent and dependent alone on a Horizon deficiency.
You mentioned that there was pressure, and then when you went on to explain that, you explained it in terms of pressure to administer disclosure requests.
Yes. I didn't feel... I'm so sorry, I interrupted.
Was there anything other than the normal work pressure that one has to deal with disclosure requests and late disclosure?
No. I didn't, for instance, I didn't have any... apart from an email that's in the bundle talking about the difficulties of the workload for investigators, I essentially had no communications for anybody higher or in a wider capacity than my instructing solicitor and the investigator, John Longman.
Can I turn then to your earliest involvement in
Yes.
the case? And I think you received written instructions to settle an indictment, to advise on evidence, and to appear for the prosecution at trial.
Yes.
I wonder whether we can look at that, please. Poll 304 4585. We can see the summary of what you're asked to do in the underlined, emboldened and capitalised section at the top. Instructions to counsel to settle indictment, advise on evidence and brief for the prosecution. And I think this marks your first involvement in the case.
Yes, that's right.
And if we go to page 3 and look at the foot of the page, please, we'll see that these instructions from John L. Singh and Mr. Taylor, a senior lawyer and legal executive respectively, are dated a day in February 2009.
Yes.
We haven't got the original, we've got the one that's been pulled from a computer, and so the exact date to be inserted, presumably in hand writing, is not included.
Yes.
And so if we look at page 2, please, and the foot of the page, please. Bottom 2 paragraphs, your solicitors ask you to advise on evidence, and in particular, whether you consider any additional evidence is required, appear at the prosecution at a plea and case management hearing on the 20th of March at Guildford Crown Court. So that's the request, yes?
Yes.
Can you tell us what an advice on evidence is to your understanding, ignoring for the moment here the particular or specific request for consideration of any additional evidence?
Yes, an advice on evidence is required by most prosecuting authorities in almost every kind of case, from the most straightforward to the most complex. Sometimes an advice doesn't need to be in writing. A telephone advice will be ample and it will be sufficient. Sometimes more detail is needed. But the advice at this stage would simply involve counsel looking at the papers, checking the proposed indictment, which counsel would then draft, as was then the practice for the Post Office. I, as counsel in this case, would have looked at the witness statements, the exhibits, the unused material, the schedule that was prepared at this stage, and also the internal investigator's report, just to check that everything was in order. And I did that in this case. I didn't provide...
Sorry to interrupt you, Mr. Tatford.
Yeah.
I was asking at a general level to
Yes.
start with, rather than what you in fact did or didn't do in this case. So an advice on evidence is what?
Oh, it's advising where, first of all, overall, is there a reasonable prospect of a conviction?
That's what I wanted to understand.
Yes, no, forgive me.
This document can come down. Thank you. So an advice on evidence in the context of criminal proceedings is an advice as to evidential sufficiency to sustain the allegations.
Yes.
It's not an advice about, or only about, what future evidence or other evidence we might obtain. It's an assessment of whether there's a realistic prospect.
Yes, the assessment of that, assessment of the public interest, assessment as to whether it's the right charge, and then after those more important matters, then perhaps a consideration of what evidence might be missing, whether everything is in order.
Can we turn to your witness statement, please, page 20. And on page 20, if we can look at paragraph 41, please. And the fourth line, I did not provide a written advice on evidence at this stage. This was not unusual in a case whereas here I'd been provided with all the necessary paperwork and the case appeared properly prepared. So you were instructed to provide a written advice on evidence, but you didn't.
Well, I think when counsel is instructed to advise, I'm not sure it's necessarily in writing, but sometimes it will be. What I did in this case was to look at the evidence, to look at the indictment, to consider the various matters I've outlined, and to formed a view about it. I can't remember now whether I telephoned Jarnail Singh, but one of the main results of advising on evidence is drafting the indictment, because it's a shame these days counsel isn't required to draft indictments more regularly, because if you have to draft the indictment, you really have to read the papers. And so by drafting the indictment, you'll have a very full understanding of the case and be in a position to advise in a fairly brief and succinct way as to all the issues I've outlined.
You give us the reasons for not preparing an advice here, that you'd been provided with the necessary paperwork and the case appeared properly prepared. Evidential sufficiency requires an examination of that paperwork, doesn't it? Not just whether there are pieces of paper in the brief. And you say that the case appeared properly prepared. Did you in fact look at the substance of what the evidence disclosed, as opposed to whether it appeared well arranged?
Oh yes, no, it's not a question of arrangement. It's looking at the case summary, looking at the investigator's report, which is often more detailed, and then checking the evidence. What I was able to do, because I was familiar with this sort of case, was to see that it was in order. I could do that fairly quickly because I was familiar with this sort of horizon deficiency case, where it appeared to be a straightforward deficiency case.
To what extent did you understand at this time, and so early 2009, that the Post Office relied upon independent counsel advising on the sufficiency of evidence as part of its governance and oversight of the prosecutorial process?
Oh, I realised that was important to them. They relied on barristers much more, for instance, than the CPS.
We've heard a number of witnesses say, a part of our system was the use of the independent bar, and a member of the independent bar advising on realistic prospect of a conviction, and some of them have said, and on the public interest too. Did you do that in this case?
Yes, but I think I did it in writing later on.
Sorry to speak over you.
No, forgive me.
We've got to get through some
absolutely,
some work.
Absolutely.
There is an advice dated the 5th of January 2010, which is an advice about principally disclosure,
Yes.
not about whether there's a realistic prospect of conviction. Was there ever any written advice on evidential sufficiency or public interest?
Not written advice, but I gave telephone advice to Jarnel Singh on the day of the PTPH, because we discussed pleas.
Right. And so that was on the 20th of March, is that right?
Yes.
And so between receiving the instructions and the PTPH, in fact, I think back in the day it was a plea and case management
Yes.
hearing, you hadn't advised on evidential sufficiency and public interest?
No, I don't think that was. I don't think that was particularly surprising. I don't know exactly when the brief came through, but I had advised on the indictment, and I took. Well, when I advise on the indictment, I'm essentially saying, at least by implication, that there is a reasonable prospect of conviction. Otherwise, I wouldn't be drafting the indictment. I'd do an advice to say there was no prospect of a conviction.
And so the fact that you settle an indictment is an implied statement that there is a reasonable prospect of securing a conviction on the counts that you settle.
I think so, yes.
Does that mean that you don't separately, where you're settling an indictment, advise in writing?
No, I think I did relatively few written advices for the Post Office and indeed for the CPS at this time on fairly straightforward cases. I'm not seeking to diminish the importance of cases, but instructions counsel is to advise. There isn't a time limit in the instructions, I think, and it's an ongoing process.
What's the importance of that point, that there wasn't a time limit?
Well, in this case, for instance, this case changed, but I took the view that my duty was to read the papers, to draft the indictment, and I would only do that if I was satisfied there was a reasonable prospect of conviction. And then my view was that I had complied by doing all of that with my instructions, because those are the instructions that come in every single brief. Counsel tries to do written advice as often as possible, but there's simply not time, I'm afraid, in every single case.
And so was it usual in Post Office cases for you to be requested to advise on evidence, but you not formally to do so? You either do so by a phone call or by settling the indictment, which carried the implication that there was sufficient evidence? Yes,
I think so. And the instructions were very much those were the instructions, I think, in every brief. So it was part of the pro forma of the brief. That's not to underestimate the importance of that. It's vital that prosecution counsel does review those matters.
Thank you. That document can come down. As we've seen from the instructions, you were also requested to settle an indictment. Can you explain for those who don't know what settling an indictment means, please?
Well, it means setting out the charges that fit the evidence. So in this case, it was one count of theft and various counts of false accounting in relation to various monthly branch trading forms from the office, the West Byfleet office.
I think you've confirmed this already. In your view, settling an indictment carries with it an implication that there's a realistic prospect of a conviction?
Yes.
Would you not accompany your advice by setting out an analysis of evidential strengths and weaknesses and where the public interest lay?
In an ideal world, yes. But I'm afraid there is simply not enough time to do that in every single case. It's simply impossible. The Post Office, I think at that stage, paid counsel for written advices, so there's an incentive there. But for instance, in every single case, it's simply impossible. The workload is too great. We would all love to do that, but I'm afraid even back then, and more so now, it's very difficult to do written advices for every single case.
Accompanying the indictment was a schedule of charges.
Yes.
Can we look at that, please? It's poll 3045010. This accompanied your brief and your instructions. And are these the charges in respect of which Mrs. Misra had been committed by the Magistrates' Court to the Crown Court?
Yes.
And we can, if we pan out a little bit, see that charge 1 was a theft allegation of stealing 74,000 odd pounds, and the remaining 4 are false accounting charges.
Yes.
As you said. So 1 theft, 4 false accounting. And the date range in the theft allegation is 15th of November 2006 and 14th of January 2008.
Yes.
You say in your witness statement, oh, I'm so sorry, I wonder whether we can turn to poll 305-1092. We can see an email from you to John L. Singh on the 10th of March saying, please find indictment attached for Misra, which needs to be lodged today. And I think we'd seen in your instructions that the deadline for you settling the indictment was indeed the 10th of March. And then if we can look, please, at poll 305-1149. We can see an indictment. You say in your witness statement that you do not believe that this is a copy of the indictment that you settled, and instead it was a copy included in your papers as a draft indictment.
Yes, I think that's right, yes.
Just dealing with those two things separately, why it might not be a copy of the indictment that you settled. I mean, plainly it wasn't the one enclosed with the email, because we can see a T number written in hand on the top right-hand side. That wouldn't have been included in the attachment to your email, would it?
No.
If we look at page 3, please. At the foot of the page. We can see it's dated the 16th of March 2009, again in hand, which is after your email of the 10th of March. Yes?
Yes.
And then if we look at the very foot of the page, we can see that there's a character string suggesting that this document may have come from a drive, or may have been saved in a drive relating to John L. Singh. Can you see that?
Yes, I do.
So that, I think, it establishes the first part of the proposition, that it's not the one that was attached to your email. But you tell us as well that you think this was a copy included in your papers as a draft indictment. That's unlikely, isn't it, given these features, the 3 features?
Yes, no, that's right, looking at the dates. I said that, I think, because there often would be a draft indictment.
Well, the instructions that you received set out the enclosures, and draft indictment isn't one of them.
Oh, well, I've missed that. That's me making a mistake because of other cases then.
I just want to look at the substance then, whether this looks to be the indictment that you settled, albeit dates and signatures have been added after you settled it. Can we just look at page 4, please, which is the next page? And scroll down, and scroll down. Is that the kind of back sheet that you would prepare when you were settling an indictment?
No, I wouldn't do a back sheet. If I sent an indictment by email, I would simply send it as an attachment to the email, I think. A back sheet, around this time, that we were still not using computers anywhere near as much as barristers use them now, but I'd only attach a back sheet to a written piece of work, which would sent in the DX.
And if we just scroll up, please, we can see this has got a received stamp on it of the 11th of March 2009, the day after you settled it. Did you think you sent one out in the post or by DX too?
Oh, no, I don't think so. I think I simply sent one out by email. The reason, just the reason I don't think this is the indictment I drafted is simply because of the formatting. I don't think I'd have underlined names in quite the way it is. I may be in error about this because I've noticed my formatting generally is very different from how I'd format matters now. Looking at the dates, this might well be the indictment I drafted. I thought that it wasn't because the way that it's formatted, but I'm not sure, I'm afraid.
Okay.
I don't think there's any significant difference between the indictment I drafted and the original draft.
When you say the indictment that you settled down, the original draft, what are you
And,
referring to
the
as an original
charges.
draft?
I think going from in this case, as there wasn't a draft indictment, it'd be the charges. So I used the charges, I compared them against the evidence and drafted the indictment.
Well,
Maybe, I'm so sorry, sorry.
In fact, if we look back at page 1 of the indictment, we can see that there are some material changes. The theft count, you can see the period of the alleged theft has expanded in terms of its start date. Can you see that?
Yes.
And this remained so, including up to the point of arraignment and at trial, 29th of June 2005. And then if we look at the accounts, remembering previously there were 4 counts of false accounting, if we just scroll through this document. And keep going. And keep going. We can see there are 7 counts in total, 6 counts of false accounting. So it's expanded from 4 to 6. You think that was your work,
Oh, yes. Certainly the focusing on the date is helpful because I'd have begun it with the beginning of Mrs. Misra's time at the West Byfleet office. The more I look at this, it may be I was misled by the way it's formatted. This may well be the indictment I drafted. I'm sorry if I've made a mistake about that.
That's all right. Just going back to count 1 then, the theft, and I think you've just said that you expanded the period of coverage from the date that Mrs. Misra started in the post office at West Byfleet, that being the 29th of June 2005.
Yes.
At the point of settling in the indictment, had you got anything such as ARQ data?
No.
Did you subsequently receive ARQ data?
Well, it was certainly. I think I did. I must have done. The defence was served it. I would have had it served at the same time. I know I advised that it be served on a disc. I think they wished to print it out. I'm trying to remember whether I had a full copy myself, but I would have thought I did, but possibly just on a CD-ROM.
Thank you. If we just look at some other material that may help you.
Of course.
FUJ 0012 2707. This is Penny Thomas, an employee of Fujitsu. Her witness statement for the purposes of the Seema Misra prosecution, dated the 4th of February 2010. You can see what she says in the opening paragraph. We just scroll down a little bit. To remind you of who she was. And then if we turn to page 5, please. In that first substantive paragraph, she produces a copy of some ARQs and she gives the number as her exhibit PT1 and produces a CD as her exhibit PT2.
Yes, I see.
And then if we go to page 7, please. This is a document that she attaches to her witness statement, which appears to give the date range of the ARQ data that she was exhibiting. And can you see the date range in the right-hand column, three
Yes.
boxes down? 1st of December 2006 until the 31st of December 2007. That period is a limited period covering only the false accounting charges rather than the whole of the theft period, which ran from when Mrs. Misra took over West Byfleet on the 29th of June 2005 to the 14th of January 2008. Do you know why that was? Why the ARQ data was obtained for a different period of time than the allegations in count one?
I think this ties in with the what I set out in my abuse of process argument, because the Post Office told me that because of their contractual relations with Fujitsu, they wouldn't be able to have ARQ data to cover the full indictment period, and I set out the reasons as to what I was told about that in my abuse of process argument. I acknowledged straight away that the Court of Appeal in Hamilton has said that the full material must be served, but I've set out the explanation as to why a shorter period was chosen. It is to do with the cost and the contractual arrangements, but also a shorter period was chosen so that there could be a focus on a time when the data may not be affected by the thefts that Mrs. Misra said that she dealt with.
So that's the explanation, cutting through matters that you put when cross-examining the defence expert, Professor McLachlan.
Yes.
You said, I'm not going to turn it up for the moment. The rationale behind why you were given that 13-month period, i.e. December 06 to the end of December 07, is because it's not tainted by any suggestion of theft, i.e. suggestion of theft made by Mrs. Misra. It's clean data to look at the computer, for computer error.
Yes, not tainted by theft by employees of
Yes.
Mrs. Misra, not Mrs. Misra herself. It's to clean data to focus on whether any patterns could be seen that might be suggestive of horizon problems. It was really to focus on the three possibilities, that possibility that was raised by her defence at the trial.
Mr. McLachlan, Professor McLachlan replied, but I requested the data for the entire period. And you said, I fully accept that, but if one requested and received every piece of paper for West Byfleet, we would probably fill this room. Is that your understanding of why the data was not requested for the entirety of the period of the theft count, i.e. cost and volume?
Cost, volume, those were the main reasons, I'm afraid. It was also, there was the additional consideration of an untainted period, but the dominant factors were cost. The dominant factor was cost and the contractual relationship with Fujitsu, I think.
I think you candidly accept in your witness statement that, on reflection, this was the wrong approach.
Yes, very much so. And, well, I set out reasons for that, I agree. Yes.
Would I summarise them correctly, that as follows: the Crown chose to charge an ongoing theft over a long period of time?
Yes.
Once the defence raised the reliability of Horizon, disclosing the Horizon data for the whole of the indictment period was not a matter of disclosing unused material. It was also the primary evidence upon which the Crown relied in order to prove that the property belonging to another had been appropriated by the defendant.
Yes, that's right. It was served as evidence.
In other words, that data was necessary to prove the elements of the offence of theft.
Yes, I'd agree with that.
and therefore Mrs. Misra was entitled to receive the entirety of the data for that period as served evidence so that her expert could analyse it and see whether the Crown had indeed proved its case.
Yes, I certainly would agree with that now. I've explained the reasoning. I think the reasoning now was wrong, as exposed by the Court of Appeal, but actually the way that you've exposed it, it shows that it's wrong simply in its basic logic.
Did you, thank you, that document can come down. Did you consider that the theft and false accounting charges were essentially alleging the same criminal conduct?
No. I was aware of the case of Eden, which I referred to in my abuse of process argument, and that the Crown has to consider very carefully whether to charge both types of offending. In this case, it was fully justified because it allowed Mrs. Misra to plead guilty to what she accepted, but also allowed the Crown, if it had the evidence to do so, to pursue the clearly more serious allegation of theft.
And so these were separate offences reflective of two different types of alleged criminal conduct?
Yes.
The first being a theft charge relating to the alleged stealing of the money, the second being a false accounting charge, or a series of false accounting charges relating to the alleged covering up of the theft.
Yes, the false accounting was the covering up, but Mrs. Misra in her interview suggested she was covering up for thefts of others. So there was a different motive for that offence, which made it a less serious offence. If she was only convicted of that offence alone and found not guilty of the theft, she'd get a very different sentence. That's why I thought that it was very appropriate to have the two different kinds of offending, albeit they're linked, but the motivations were different.
Can we turn to the plea and case management hearing? That took place, as we've said, on the 20th of March 2009. And you address what happened at page 20 of your witness statement, paragraphs 42 and following. If we can turn that up, please. So page 20 of your witness statement. Uh, 42, please. And I'll just read these aloud. The PTPH, as I've said, I think it was a plea and case management hearing, took place on the 20th of March 2009. I have a recollection of being asked by Andrew Castle, the solicitor advocate for Mrs. Misra, whether the pleas to false accounting would be acceptable. I'd anticipated being asked this question as it was obvious from the papers that such an offer was going to be made. I'd formed a view before the inquiry from Mr. Castle that such an offer should not be accepted because the suggestion that Mrs. Misra had been entering false figures over a considerable period only to cover the thefts by members of staff seemed clearly refuted by the fact that her false figures continued to rise long after the dismissal of the alleged thieves. The figures would simply reach a false plateau if the source of loss ended. Instead, they continued to rise, suggesting the loss was continuing in spite of the sackings. The obvious inference to me at the time was that the hole in the accounts was growing because Mrs. Misra was stealing money. It seemed far more rational that Mrs. Misra would use false accounting to hide a hole created by herself than by others. My experience from other cases was that a sub-postmaster whose shop was struggling might borrow money from the funds of their sub-post office to put into their shop, hoping in due course they'd be able to return the money into the post office before an audit occurred. In the absence of an audit, the sub-postmaster could hide the hole in the accounts by false accounting. Only the stocktake involved in an audit could reveal the true deficiency. That was my opinion, but as I only act on instructions, it was essential for me to discuss the plea offer with my instructing solicitor. My recollection is that whilst at court, before the hearing, I telephoned my instructing solicitor, John L. Singh, to discuss this. He agreed that the pleas were not acceptable. I don't remember exactly what was said, but the advice I would have given would have been along these lines. The account the defendant has given in interview that she was the victim of thefts by former employees didn't fit the evidence. The apparent hole in the accounts increased after the dismissal of the stealing employees. I thought it did not make sense that Mrs. Misra would cover up by false accounting a loss caused by the dishonesty of others. A desire not to lose the sub-post office did not appear to explain false accounting on such a scale because there would be no point in keeping hold of a business that was hemorrhaging so much money. The defendant said in interview she'd only reported a tiny fraction of the thefts to police. This did not make sense to me because she was obliged by common sense and by her contract to report the theft. If she was prepared to report the theft, why not report all of it? Now, in fact, that can come down, thank you. It appears, and you may have forgotten this when you made your witness statement, that Mrs. Misra pleaded guilty to the 6 counts of false accounting at this plea and case management hearing.
Oh, yes, I didn't mean to suggest anything else. I was asked whether that would be acceptable on its own. I said no, having taken instructions, but then she entered her pleas. I don't know if that's the precise order, but she certainly entered her pleas. I didn't mean to say otherwise.
Thank you. Can we look, please, at poll 305 1441? This is a letter dated the 13th of May, so 2 months or so after the PCMH, to you, or in the old-fashioned way, to your clerk. And you'll see that, if we scroll down, thank you, right at the foot of the page, it's from Mr. Taylor, a legal executive within the Criminal Law Division, co-author of your instructions. He says he'd received a telephone call from John Longman, the investigating officer who took over this case from Adrian Morris. Counsel recall the defence letter dated the 16th of March 2009, so that's 4 days before the PCMH, which advised the defendant would plead guilty to all counts relating to false accounting, but not guilty to theft. Counsel will recall that subsequent to that, by letter dated the 9th of April 2009, the names and addresses of 3 people who worked at the sub-post office at various times were notified to the prosecution. John Longman has attempted to contact these people and has attended their addresses. None of them now live at the addresses, given one is believed to be living in India. Bearing in mind the matters which the defendant set out on pages 13 and 14 of the exhibit bundle, John has asked me whether it would be in the public interest to continue with the prosecution. Myself or Janelle, who is aware of this matter, would appreciate counsel's advice as to whether or not it would be sensible to continue with the prosecution or to accept the false accounting charges. So, essentially summarising, the investigator was wondering, in the light of the allegation that other people had been responsible for the thefts, whether it would be in the public interest to continue with the prosecution, i.e. the prosecution for theft, because that was the only contested allegation that remained.
Yes.
Can we turn, please, to poll 304 7864? That's an errant reference. Poll 304 7864. That seems to be it. Can I try the reference that I was originally going to seek to display? Poll 305 2586. Poll 305 2586. I'm sorry, sir, there appears to be a ghost in the machine. I wonder whether you would mind taking a 10-minute break now, slightly earlier than usual, whilst we sort that out.
No, that's fine, Mr. Beer. So what time should we start again?
Maybe 5 past, please.
Yeah, that's fine.
Thank you very much. Good morning, sir. Can you see and hear me?
Yes, I can, thank you.
Apologies for that interruption. Can we display, please, poll 305 1586? And can we look at the foot of this page, please? We can, if we scroll down a bit more, thank you, see an email from Phil Taylor, the legal executive, to you, dated the 22nd of May 2009, and we can see that the Misra case was in a warned list, according to the title to the email of the 12th of June 2009, yes?
Yes.
And he says, "Hi Warwick, I'm just a little bit in the dark about Misra. You will recall there is one count of theft and some false accountings. The defence will plead guilty to false accountings. In fact, of course, you already had by then, as we've established. And John Longman is fairly happy for us to accept those pleas. In fact, those pleas, as I say, had already been entered. However, we're some 70-odd thousand pounds light at the moment, as I understand it. And if we just accept the false accountings, it's very difficult for us later to obtain a confiscation order and subsequently compensation out of the confiscation. Could you let me have your views on this? I'd be very grateful to hear from you. That can come down, thank you. You will have seen there that Mr. Taylor appears to be drawing a link between the decision whether to proceed with the theft allegation or be content with the false accounting pleas, and whether it will be possible to obtain a confiscation order, doesn't he?
Well, he draws a link. He seems to be ruling it out, but yes.
Seems to be ruling what out?
Well, he seems to understand that confiscation, which is my view, would be very difficult with false accounting. But, well, I can explain further, but I'll wait for your question.
And so you agree that he's drawing a link between whether we accept the pleas or not by reference to the availability of a confiscation order?
Well, he is making that link. He's not a lawyer. He's very much a caseworker. He would be called a caseworker in the CPS, albeit he was extremely experienced. His main concern was preparing cases, so witness bundles, organising witness availability and so forth. It seems to me that he's just approaching everything in the round and asking what's going on, but simply because he doesn't know about what I've discussed with John L. Singh previously. In your witness statement, you tell us, it's paragraph 43, there's no need to turn it up, that you had always taken the view that the availability of a confiscation order was an irrelevant consideration in making a charging decision. Yes. And do I take it from that an irrelevant consideration in deciding whether to accept pleas or not, or continue with counts on an indictment? I think so, yes. And is it right that's always been your view? Yes, confiscation is a consequence on conviction. It's not it's out of place, it seems to me, in any consideration of the public interest and what's acceptable as a plea. I was going to ask you why you hold that view. Is that it, the reasons you've just given? Yes, no, precisely. And it depends on other factors, such as whether the defendant has any means. But those are factors to be looked at after pleas are decided. Seems to me to muddle the two is very dangerous. And why is it very dangerous? Because cases should be prosecuted if the offence and the evidence merits it, not because of the consequences. And that applies to other orders as well, I would have thought. Disqualification orders of different sorts of offences. I think it's important to draw a distinction between what the evidence shows, what is in the public interest. That has to be looked at in terms of charges and acceptable pleas. Consequences then follow automatically according to the law. I think they do need to be separated. That's my view. If we just go back to the email, please, poll 305 1586. And look at the middle passage in the email chain. There's your reply of the 22nd of May, same day. Dear Phil, I've spoken to John Longman about this case. Just stopping there, would that be spoken
at this time, i.e. May, or are you referring back to some previous occasion?
I'm not sure, but I think it's previously. I wouldn't be. It may have been back at the time of the PTPH. John Longman might have gone along for that, but I don't know. I'm not entirely sure. I think I've spoken to him prior to this communication. It's not at the time of this communication, but I'm not absolutely certain about that.
And was that usual for you to have direct communications with Post Office investigators?
Yes, I tried to do that as much as possible because I found, as indeed with police officers, one can achieve a great deal by having that contact with the investigator. I try and get their mobile number as soon as possible in any case I prosecute. It saves an awful lot of unnecessary, it saves a lot of time and it helps get on with the case.
And what about an audit trail of such communications? How's that kept?
Well, the audit trail, I suppose, these days will automatically follow from email. I wouldn't expect to have to set out an audit trail for every phone call I'd had with an investigator in any case.
And so the answer is that there isn't an audit trail?
No, it's one reason I do try these days to use email for that reason. But there won't be an audit trail, and I don't think there's any requirement for any audit trail for that sort of situation.
That you continue, the case for theft is strong and we should not accept the pleas. Confiscation would also be a non-starter if we did. John is making some further inquiries about the thieves and the defence has given us details for. It may be we've been given false details which may strengthen our case. Do call me on your number if you'd like to discuss further. So you address evidential sufficiency of the theft charge first, yes?
Yes.
And then you continue, confiscation would be a non-starter. If the availability of confiscation was an irrelevant consideration in deciding whether or not to commence or to pursue charges, why are you addressing it here?
I'm addressing it because Phil Taylor's addressed it, and I want him to know my full position. But what I mean by my sentence structure, the full stop is meant to be there. The case for theft is strong. We should not accept the pleas. Full stop. That's the end of that consideration. Confiscation would also, that also is important. That does reflect, I hope, exactly what I've said about how I approach confiscation and after considerations of pleas. So my grammar is quite deliberate there.
Did you ever gain the sense when prosecuting for the Post Office that recovering money through confiscation orders was a very important consideration for the Post Office?
It's an important consideration. I never got the impression that it was any kind of decisive reason for any prosecution. The Post Office were they're most keen ensuring that confiscation orders were turned into compensation orders so that they would get the money. But they were realistic about defendants' means and so forth. It was an important matter for them, as it should be for any prosecuting authority. I didn't get the impression it was of vital importance in every case. It was a consequence which they took seriously.
Thank you. Can we move on to the first trial then, on the 2nd of June 2009? If we can look at your witness statement, please, at page 23. Bottom paragraphs, please, from 46 onwards. You say the trial was placed in a warned list and the case eventually listed for trial on the 3rd of June 2009 before Recorder Bailey. It was on this day that concerns were raised for the first time in the case about the integrity of Horizon. The attendance note of John L. Singh, and you give a reference, seems to set out accurately what happened on the, you call it the 3rd of June, I think as we'll see it's the 2nd of June,
After
when Mrs. Misra's trial was listed. I think I saw the attendance note at the time. I was often attended upon when I prosecuted. It wasn't unusual for the reviewing lawyer to attend the first day of the trial, etc. And then if we go down to paragraph 48, until I saw the attendance note, I had believed that defence counsel was Keith Hadrill. This was mistaken on my part because of Mr. Hadrill's later role as trial counsel. I was involved in a couple of cases with Mr. Cousins around the late 90s and early 2000s, and I do now think he was trial counsel on 3rd of June 2009, but I'm not 100% sure. I do remember clearly that Defence Counsel produced a photocopy of a Computer Weekly article about alleged problems with Horizon and complaints by various sub-postmasters. This was the first time in the case that I was made aware of the issue of Horizon IT reliability, and the first time I was informed about problems at the various sub-post offices referred to in the Computer Weekly article. So that can come down, thank you. Defence Counsel produced a copy of an article from Computer Weekly. That was dated the 11th of May 2009, so only a few weeks before the trial was due to begin on the 2nd of June 2009. And then can we go back, please, to your witness statement, please, page 26. And just pick up the end of paragraph 50. Last three lines. All I did know, this was an important new issue that needed to be considered properly by both sides. It was therefore vital for there to be an adjournment, and the trial was indeed adjourned, yes?
Yes.
In 51, you tell us about a new firm of solicitors. I'm going to skip over that. 52, you tell us, I realised we were about to embark on a demanding disclosure exercise. I was conscious that both sides were treading new ground, and the only guide I had so far was the Computer Weekly article. As I thought about matters, it seemed to me it would be important to focus on the West Byfleet sub-post office and consider whether any Horizon problems had occurred there. Complaints from sub-postmasters about problems at different offices might raise evidence of a problem that could be examined in relation to West Byfleet. But it seems to me that a simple complaint by a sub-postmaster was of very limited assistance. There'd need to be evidence of what the problem was, or at least what its symptoms might be, i.e. the location within the office stock where the loss appeared to arise. I discussed the way I was thinking with, over the page, Keith Hadrill, and it was decided there should be a joint visit to the West Byfleet sub-post office. From your diary, you can say that this appears to take place on the 6th of November 2009. That can come down, thank you. What was the purpose of visiting the branch?
Oh, to see Horizon in use by the staff there, and also to get an idea of how the branch was, the geography of the branch as a whole. It's always helpful to look at the shop premises. But the main purpose was to ensure that both sides had seen Horizon in action at the West Byfleet office.
Did you think that there was a problem with the hardware in the branch?
No, because I had the evidence of Mr. Varsani, who took over control of the branch. He ran other branches as well, and he reported no problem.
Did you think that the problems raised in the Computer Weekly article related to the operation of hardware in a branch?
I wasn't sure about that. That seemed likely because they related to individual offices widely spread apart, but I wasn't sure because there wasn't enough detail. For instance, the Calendar Square issue, which I became much more informed about, which very much was a hardware issue within a branch, as I understood it. I wasn't clear of the detail from the Computer Weekly article, but I was trying to keep an open mind.
With hindsight, do you think addressing a series of concerns raised in the Computer Weekly article in the operation of the Horizon system would be addressed by going and looking at hardware in a branch?
I simply thought it was a good place to start because our case was concerned with West Byfleet, and I wanted to ensure that the defence saw how it operated. Because I was aware from other cases that sometimes there were misunderstandings about what the system was like. and what it looked like to operate.
Can we look, please, at poll 305 3393? Thank you. If that can just be blown up a little bit. We can see it from the foot of the page. It's from Mr. Taylor. And then at the top of the page, we can see this letter is dated the 15th of October 2009, so a couple of weeks before the site visit. It's addressed to Post Office Security with a copy to the investigator, Mr. Longman. Reads, Prosecution Counsel Warwick Tatford has been discussing this case with Defence Counsel Keith Hadrill, both of whom are resident at your chambers. What they have decided is to visit West Byfleet premises, and perhaps somehow someone can show them the Horizon system in operation, which will hopefully knock on the head this business about the defence requiring so many years' worth of Horizon data. Was that your purpose, visiting the branch to knock on the head a request for years of Horizon data?
No. I wanted the defence to see how Horizon worked, and that would inform their disclosure requests, but I wasn't seeking to end proper inquiries.
How would viewing the hardware in the branch inform their disclosure requests?
Well, it would inform them a great deal, because most of about half of their disclosure requests weren't about Horizon at all, but weren't about computer problems at all. They were about how easy the system is to operate, and the prospect that how errors arise. And that's exactly what one could have a good idea about if you saw somebody using the system.
Do you know where this idea that a demonstration of the operation of Horizon on a particular day, years after the events in question, was seen as a replacement for providing Horizon audit data at times relevant to the events in question?
Well, I never saw it. I never understood that it was an alternative. Forgive me, I can't see. This is a Phil Taylor's letter, I think.
It is, yeah.
That the wording is very in character for Phil Taylor. Knocking on the head, for instance, isn't a phrase that I would use, but I can imagine him using. I suppose it certainly was right. We were using the visit. I hope the visit would help focus disclosure requests. We'd given an explanation as to why we thought a particular span was appropriate, and that was still being considered, as I understood it, by the defence, and I thought overall they'd be helped by seeing the equipment. I appreciate now, with hindsight, that's wrong, but at the time that appeared sensible.
And why, with hindsight, is it now wrong?
Well, because with hindsight, I now know that there are lots of problems about Horizon which are completely out of my knowledge. I had no idea of anything that has been discovered since. At this stage, I knew nothing other than the Computer Weekly article. And I hope that a visit might give some focus.
When we come to the trial a year later, we'll see in due course that when you opened and closed the case to the jury, you said that how can there have been a computer problem, I'm summarising, when if there was a computer problem, it would have been evident to Mrs. Misra because she was the one who was operating the computer.
Yes, I can explain what I mean by that, because I've seen that phrase. I'm aware of various
Online
criticism. And what I meant by that, and I hope this is a valid point, is that if there is a problem, Horizon gives you a lot of opportunities to see where the problem might be arising. It delivers fruitful inquiries because, as indeed Mr. Varsani said in his evidence very clearly, he was able to find the source of a problem by working through Horizon, the various printouts. I'm not suggesting that one can see a computer problem from the screen of Horizon. You can't, that's obviously right. But what you can do is search the office from top to bottom using all the printouts Horizon can give to get a full idea of where the problem might arise, as indeed Mrs. Miser had done when she was able to identify thieves. And she did that by using Horizon, as I understand it.
Did that belief, the belief that you've just expressed, inform your thinking of the desirability or necessity of a site visit? Let's go down to the branch and see the system in operation.
Well, it did inform it. I thought it would be helpful to everybody.
That can come down, thank you. I'm going to turn to the appointment of Mr. Jenkins in the Misra case. Can I start, please, with some general questions concerning the duty of a prosecutor in relation to an expert witness? Would you agree, and these propositions I'm about to put to you come from the evidence that the chair of the inquiry has heard from Mr. Atkinson, King's Counsel, that a prosecutor intending to rely on expert evidence in criminal proceedings was subject to an obligation, firstly, to satisfy themselves as to the expert's relevant qualifications and expertise.
Yes?
Secondly, to satisfy themselves that the expert had been appropriately instructed, including by the provision of a written and detailed letter of instruction or an email of instruction, all being provided with written terms of reference.
Yes.
Thirdly, under an obligation to satisfy themselves that the expert was provided within the instructions with identification of what it is that his or her opinion is sought on and set out issues or questions that he or she is expected to answer.
Yes.
Fourthly, a prosecutor is under an obligation, would you agree, to provide guidance as to what it is the expert is being asked to do and what material they are being asked to consider in order to undertake that task?
Yes.
Fifthly, a prosecutor is obliged to set out the material upon which reliance has been placed in the prosecution and which may be relevant to the questions which the expert is expected to answer.
Yes.
And lastly, a prosecutor is obliged, would you agree, to inform the expert as to his or her relevant duties?
Yes.
Would you agree, again, building on that, that even with those experts who are trained, accustomed to, or who make their living by giving expert evidence, i.e., even if you were preaching to the choir, a prosecutor has to make sure that an expert understands what their duties are?
Yes.
A prosecutor, would you agree, is under an obligation to satisfy themselves that the expert had understood in the first instance and then complied with their relevant duties to the court?
Yes.
That was a necessary duty in order that the prosecutor could be sure that the expert evidence was admissible as a basic condition of admissibility.
Yes, no, that's right.
And lastly, would you agree a prosecutor was under a duty to satisfy themselves that any material or indeed literature which might undermine the expert's opinion was reviewed by the prosecution and, if potentially relevant, disclosed not only to the defence but to the expert?
Yes.
Before we get into the weeds of emails and letters and draft witness statements, would you agree with the following 3 points, just as a matter of generality and stepping back? Firstly, Mr. Jenkins was never provided with a written document which met any of the requirements that we have just identified.
Well, that appears to be right. I think I may have assumed that he had been, because I worked on the assumption that he'd been instructed properly. But I should have checked that, and I didn't. My assumption was wrong, perhaps.
Would you agree that there's no documentary record which can be pointed to that confirms that Mr. Jenkins understood any relevant expert duties of which he was subject.
Well, I think that must be right, because I haven't seen anything, and it would have been shown me if it existed.
And lastly, there's no documentary record which confirms that any prosecutor themselves, any part of the prosecution team, was satisfied that Mr. Jenkins understood any of the relevant expert duties to which he was subject.
No, there appears to be no document, that's right.
Would you agree that by at least 2009, 2010, the time that we're considering, in fact it had been the position for many years before, the following were necessary inclusions in an expert report? Firstly, details of the expert's academic and or professional qualifications, their experience, their accreditation that was relevant to the opinions expressed in the report.
Yes.
Secondly, the range and extent of their expertise and any limitations upon that expertise.
Yes.
Thirdly, an expert report was required to include a statement setting out the substance of all instructions received, whether that's oral instructions or written instructions, questions upon which their opinion was sought, the materials provided by their instructing client and considered by them, the documents, statements, evidence, information or assumptions that were material to the opinions that they were about to express.
Yes.
Fourthly, a report was necessarily had to include information relating to who carried out any examinations or investigations, the methodology used, and whether or not such investigations were carried out under the expert's personal supervision.
Yes.
Fifthly, a report was required to include whether there was a range of opinion in relation to the matters dealt with in the report, a summary of that range of opinion, and the reasons given by the expert for adopting a position within that range.
Yes, I think that might depend on the particular case and what range might be relevant to the particular case, but generally I agree with that.
Yes, if there was a range.
If there was a range, yes.
If there was a range, then it should include it.
Yes.
And that carried with it a concomitant duty to set out any material facts or matters that detracted from the opinion that the expert was proffering.
Yes.
I.e. any points that might fairly be made against the opinion that they were offering.
Yes.
A report was required to include, sixthly, I think, relevant extracts of literature or any other material that might assist the defence or the court.
Yes.
Seventhly, the report was required to include a statement that the expert had complied with their duty to the court to provide independent assistance by way of objective and unbiased opinion in relation to matters within their expertise, and an acknowledgement that the expert would inform the parties and the court that if their opinion changed, they would tell the court and the defence so.
Yes.
Did you understand that those duties not only existed, but the requirements went to the substance of an expert's report, rather than just being administrative details that needed to be complied with?
Well, I certainly realise that they were requirements, and they might well determine the admissibility of the report.
So they're not just about form.
No, it's not just about form.
It's about substance.
Yes.
We know that those requirements were incorporated into the Criminal Procedure Rules, Rule 33, which came into effect in November 2006. At the time that you were prosecuting Mrs. Misra in 2009-2010, did you know that those requirements had been introduced into the Criminal Procedure Rules?
I did know they were in the criminal procedure rules. I quite clearly didn't consider them properly. I can give an explanation for that, but clearly I failed in that, and that's a clear failing.
You tell us in your witness statement, we needn't turn it up. You refer to a case called Stubbs, a decision of the
Yes.
Court of Appeal Criminal Division, that a witness who is functionally, who is not functionally independent of a party, for example, because they're an employee of a party, may nonetheless be called as an expert on behalf of the prosecution. Would you accept that in such cases where the witness is not functionally independent of the relevant actors in the case, it's all the more important that the expert witness understands and complies with the duties that I've just mentioned?
No, I absolutely agree with that, yes.
Would you agree that there's a particular duty to ensure understanding with and compliance with such duties in such a witness's case because of the particular risk that an individual whose day job is not being an expert witness and who is asked to give evidence about issues including their own work may not understand the nature of their expert duties?
No, absolutely, absolutely.
They may also have skin in the game.
Yes.
Was this a risk that you appreciated?
Oh, yes, and we were utterly transparent. I fully accept that that the statements of Mr. Jenkins didn't comply with the criminal procedure rules, but we made, and I certainly made considerable efforts to ensure that the witness did understand his duties. I accept that the best way to do it is to follow the rules. That protects all parties, including Mr. Jenkins. And I can see now that what I remember, just so the explanation is clearly understood, I do remember, particularly when I saw Mr. Atkinson's evidence, I do remember thinking that the statement that we had eventually been received from Mr. Jenkins was the final statement, which essentially was his main statement. I appreciated that didn't comply. But I was aware of the time constraints. I have a recollection of speaking with Keith Hadrill about that to check whether there was any issue as to admissibility. It's only a recollection. I can't be absolutely sure about that. I concede, though, that is nowhere near enough to comply with the rules. What I can see now is that because of the difficulties of timing and various other stresses within the case, I tried to cover the points myself by explaining things orally when that simply isn't the safe way to proceed, and I was in error in that.
Again, before embarking on the detail, would you agree that in Mrs. Misra's case, no statement relied upon by the prosecution, by the Post Office, from Mr. Jenkins included any of the necessary inclusions required by the common law and the criminal procedure rules in order to conform to the requirements of proper expert evidence?
Yes, I would. There's a reason for that, though, and it comes from I would accept the muddled way in which he was instructed. Our thinking on the prosecution side was muddled. He became involved initially in the case simply as a way of responding to the disclosure request because the officer in the case was unable to deal with that. So a person at Fujitsu needed to be identified who could help with that. And then he, by a process that is unclear to me, he was then presented to me as our expert. Now, I think I assumed that letters of instruction and so forth had been sent, and that doesn't appear to be the case. But there was muddled thinking to do with the demanding exercise of complying with the disclosure requests. And that led to muddled thinking and a failure to follow the rules. I tried to follow the substance, but I accept that the rules are there not just for form, but also for substance. And the efforts I made were not adequate, and the rules should simply have been followed. That would have been the proper way. But it started off in an unusual way, and that was the original cause of the problem. For instance, Mr. Jenkins, on my advice, was providing a series of witness statements, which essentially were responses to interim reports by Professor McLaughlin to try and assist him, because we had a flurry of these reports. And I thought it important that it was set down in writing so that Mr. Jenkins could be cross-examined on it in due course if necessary, what his position was, so that there was, in effect, an audit trail. And it was clear what he was saying. But that muddled beginning tarnished the thought process throughout Mr. Jenkins's instruction, and I regret that. It was a mistake.
And just generally, again, before we get into some of the detail, the muddled beginnings, i.e. starting the process of engaging Mr. Jenkins in any way in the case, in an unusual way, as you've just described it, that was itself the choice of the prosecution, wasn't it?
Yes. And it was a choice made because we were very concerned about complying with our disclosure obligations by responding to requests. We should have sat down and thought about it much more clearly. Our response was a knee-jerk response to the requests.
Secondly, you said that you'd assumed that a letter of instruction was sent.
Yes, I did assume that.
Wouldn't you want to see it and ensure that it had been disclosed?
I agree. I should have asked to see it.
Thirdly, you said that you complied or sought to comply with the substance of what the rules required by engaging in conversations with Mr. Jenkins.
Yes.
Is there any record of those conversations?
No, it's only my recollection.
And so if it came to an issue at court, either as to admissibility on a voir dire of the expert evidence, or in the event of challenge at trial as to what the expert had been told as to their duties, the material with which they had been provided, whether they'd been informed of their duties and the like, there would be no record which could be produced.
No, I agree. It was muddled thinking throughout, and that was... I had overall responsibility. I should have corrected that. I didn't think it through.
And if it came to that, an argument over admissibility, you would end up calling yourself as a witness.
Yes, I hadn't thought that through. I did think that was essentially impossible in the case, though, the way it was working through it, because the way that I thought we had found, which was unconventional, and certainly not in accordance with the rules, but was actually involved mutual cooperation between the experts in a way that seemed to be beneficial to both. And it was actually the only way of making progress in the case, because we were essentially having an unending circle of interim reports with hypotheses which didn't match our understanding of Horizon, but we needed somebody with expertise to explain that to the expert. We needed two experts to work together, as they did, eventually providing a joint statement where, showing agreement and disagreement. So I suspect, well, looking at it now, I was lulled into a false sense of security. This was an unconventional way of doing the right thing in this case, but it was wrong. You
say in your statement, I'm not going to turn it up, that you took great pains in all your conversations with Mr. Jenkins to make sure that he understood the duties of an expert witness.
Yes.
You explained it was his overriding duty to assist the court,
yes,
to give an opinion that was objective and unbiased, and that duty overrode any obligation that he might feel to the party calling him at the post office. You explained that it was his duty to disclose anything that might undermine his position, and that he should be entirely open with both the post office as prosecutor and Professor McLaughlin about any Horizon problems.
Oh yes, because with I had asked previously in my advice for Horizon, for Fujitsu to be contacted and to inform us of any problems, and I saw Mr. Jenkins as an obvious route to doing that. That's how I saw things, and it seemed to me, particularly from the feedback I was getting from the defence, that this approach was working.
Sorry, you've referred to the defence a number of times
Yes.
now. Are you saying that conversations with a colleague in chambers...
No, I really mean Professor McLaughlin.
I see.
It was perfectly clear to me that he found it helpful to work with Mr. Jenkins. It seemed to fit his way of doing things, because his way of approaching things was to suggest hypotheses which needed somebody to help him with. They needed to sit down together, and it's absolutely clear that they did that from the evidence they gave at the trial.
Before we get into the detail of the communications between you, the Post Office, and Fujitsu and Mr. Jenkins, if you were mindful of these expert duties and the need to make them crystal clear in somebody who did not enjoy functional independence from the party that was calling them, and you explain them to Mr. Jenkins, how is it that every witness statement which the Post Office sought to rely on from Mr. Jenkins omitted any of the necessary inclusions for an expert report?
Because until the last statement, all of those were responses to Professor McLaughlin. It is important to bear in mind that there had been an abuse of process argument that had been dependent entirely on submissions made about responses and what the defence was saying were inadequate responses. I had undertaken at that hearing to ensure that the experts would work together. That's why we did it. I was essentially trying to ensure that the undertakings I gave in the abuse of process argument were fulfilled.
How does that explain the absence of any of the required content in any of the witness statements?
Well, it should have been. They should have been in all of the witness statements. And I thought of this point particularly when the final statement was forthcoming, because as I've said, the earlier ones were meant to assist. They were essentially answers to questions posed. And the idea, my idea, was to have the final statement setting out all matters. That final statement should have complied properly with the criminal procedure rules. It didn't, but that statement wasn't available until about 2 days before the trial. And my recollection is I spoke with the defence to see if that was going to raise any problem with admissibility, and I understood it wasn't going to be, because their understanding was that the two experts were working well together, and that Professor McLaughlin needed the assistance he was getting from Mr. Jenkins.
Does the fact that none of the statements include the required content for an admissible expert report, and there isn't a single document that records the explanation to Mr. Jenkins of the existence of his duties, instead show that the Post Office and its lawyers failed properly to consider what duties Mr. Jenkins was subject to?
I think as a whole that may be right. I was trying, and I thought it had been, I assumed, it was an assumption, I assumed that these obligations were being explained by my instructing solicitor as well.
And on that point, I'm focusing on you at the moment, but you suggest that you explained orally to Mr. Jenkins some of the duties to which he was in fact subject. Given it was the Post Office's solicitors who were responsible for instructing Mr. Jenkins, and the Post Office who bore the statutory duties and common law duties in respect of disclosure, rather than having conversations with the expert that aren't recorded, did you not make it clear to or advise the Post Office that they should be the ones who should approach Mr. Jenkins on the basis that he was an independent expert, and they should be the ones that discharged the duties of compliance that I've mentioned?
I didn't make that clear because I thought that had been followed, and that's how he came to be instructed. It goes back to the muddled and unclear way in which he came forward as an expert. He went from one day, as I understood it, to the person who was helping with the disclosure inquiries, to becoming our expert. And I may have, I did assume that instructions had been properly made. I should have required to see the paperwork, as I've said earlier.
You tell us in your witness statement that the advice as to the duties that you mentioned occurred in the course of conversations with Mr. Jenkins. When did those conversations occur?
I think I had phone conversations with him, and there's also a conference shortly before the trial. I don't remember the conference, but I can see it's referred to in emails. And what I imagine I did, because it's the sort of thing I would have done at that time in my practice, would have actually had to have my Archbold with me and go through with him in the conference what the requirements of an expert was. But I don't have a recollection of the conference, but that's the sort of thing I would have done as part of my practice. But again, I have no specific recollection of that.
In relation to the phone conversations first, dealing with the conference second, was there a solicitor present taking a note of the
No.
conversations that you were having with the prosecution's expert?
No.
Is that advisable or suboptimal?
No, it's certainly suboptimal.
How would you rely, if any issue had been raised at trial, as to whether Mr. Jenkins had been informed of his expert duties, or indeed on an appeal, if your solicitors weren't making a record of what he had been advised?
Well, I agree. That encapsulates the failing.
Turning to the conference, we've seen only reference to one conference, I think like
Yes.
you mentioned in emails, of October 2010. Was that an occasion on which advice was given?
That's what I believe, although I don't have a specific recollection of it. But as I say, that's the sort of thing I would do. The whole point of meeting with Mr. Jenkins was to ensure, my main point was to ensure he understood what his job was, because I was well aware he hadn't been an expert before. I wanted to help him. I've obviously failed in that, but actually what I wanted to do was help him.
Could I turn then to specific communications?
Yes, certainly.
In the Misra case, to try and track the initial instruction of Mr. Jenkins to work out how it came about in October 2010 he was called to give evidence as an expert witness. Can we start, please, with Fujitsu FUJ 0015 2843? We can see, I think, that this is an email of the 26th of November 2009 from the investigator, Mr. Longman, to Jane Owen. Just to remind you, she was a security team advisor in the Post Office's security team, and to Andy Dunks, also a member of the Post Office's security team. You're not copied in on it, but it refers to some advice that you are said to have given. Jane, I attach a report from the defence expert where he has highlighted a number of problems with the Horizon system. That's the attachment was the second interim report of Mr. McLachlan. Our barrister, Warwick Tatford, has asked that the problems with Horizon he has raised in his report are replied to in a witness statement form. I presume that an employee of Fujitsu would have to produce the witness statement. Does that reflect the advice that you originally gave as to how Professor McLachlan's report ought to be responded to?
Yes, I advised that it be put in a witness statement so there's a witness who could be cross-examined on it, but I was anxious that he had the information as quickly as possible so we could make progress.
There's no suggestion here, if this summarises your advice, that Professor McLachlan's report would be responded to by expert evidence.
No, at that stage I didn't envisage that.
And why?
because what I thought we were trying to do was simply to give him an informed position on Horizon, and then he could provide a report rather than an interim report based on hypotheses which may not even apply to Horizon. I think, it's difficult to remember now, it's a long time ago, but I think I may have thought that if a report came forward, we might have to consider then an expert. But I didn't form any final views on this. I was doing my best with my solicitor to respond to very strenuous, wide-ranging disclosure requests, which were supported in a rather unhelpful way, I thought at the time, by interim reports from an expert. And it was a case of firefighting, which produced muddled thinking.
Can we see what the Post Office security team did with this when they received it? FUJ 0015 2847. And can we look at page 2, please? I should just look at page 3 first, just so you can see it. There's the email we've just looked at. Jay and I attach a report from the defence expert. Can you see that? And then if we look at the foot of page, if we look at page 2. Thank you. Jane Owen, the security team advisor. Thank you. If we scroll up. Forwards the email to Penny Thomas in Fujitsu saying, Penny, this is the email and attachments that we chatted about. Please let me know if you need anything else from me and if this kind of request needs to be raised in a more official way. And then page 1, foot of the page, please. Penny Thomas replies, do you know what the return court requirements are for this case, please? And then up at the top of the page. I've spoken to the investigator. He's asked any chance of having the information by Christmas. So some administrative details. Would you agree that this collection of emails is an insufficient and improper way of commissioning expert evidence from an employee of Fujitsu?
Yes, I'm not sure it's quite reached the stage of obtaining expert evidence as an expert witness, but it's wrong, clearly.
That can come down, thank you. Can we move forwards a little bit, please? That was December 2009 to your disclosure advice of the 5th of January 2010, poll 304 4557. If we look, please, at the last page, which is page 9. And scroll down, please. We can see that you signed it off dated the 5th of January 2010.
Yes.
Yes. And then if we go back, please, to page 2. You say under the heading Section 8 disclosure application, I've reviewed paperwork held by the civil and criminal departments in relation to all the case studies set out in the Computer Weekly article, which is attached to the Section 8 application. Just for those watching, what's a Section 8 application?
Oh, well, that's an application if the defence are unhappy with the secondary disclosure following a defence statement.
and they had made an application asking for disclosure of material relating to or relevant to the case studies set out in the Computer Weekly article.
Yes, they had. They hadn't at this stage, I think, served a defence statement relating to those issues at all. So it's a little cart before the horse, really, because the Section 8 application should follow on from a defence statement that actually raises the issue of Horizon. At this stage, we just simply had a defence statement saying it was other thieves in the office.
You say, in deciding whether any material should be disclosed, I've kept the following test in mind. Is there material that's capable of casting an objective doubt on the reliability of Horizon? What did you mean by casting an objective doubt?
Oh, so that there was evidence of a problem rather than simply a complaint by a sub-postmaster. So somebody so that there are records showing a problem.
What do you mean records showing a problem?
Well, there could be all sorts of records. Because the difficulty is if you have a sub-postmaster who says I have a problem, but I've dealt with the problem by putting false figures in so the account's balanced, then you don't have the evidence. You've simply got the complaint. If, for instance, this didn't happen at all from what I came across, but if a sub-postmaster had a problem, did a printout, for instance, I take a silly example because I always use stamps as a silly example. They take a printout from Horizon for the number of stamps they have in a particular stock, and the printout says that they have 100 books and they can see they only have one. They could video that, for instance, with the printout, and then that would be evidence. That would be objective evidence. Now, nobody, I don't think, ever did something like that, but that would be a way of having objective evidence, or have somebody who's seen that there's a problem.
Like a trainer?
Like a trainer, that's possible, yes. Or an expert who's been asked to look at it.
Or a more senior manager at post office?
Yes, somebody independent. An area manager, for instance.
Who've been in the branch,
yes,
watching figures mysteriously increase or decrease on the screen in front of their very eyes.
Yes.
Were you ever told about such matters?
Well, the matters, I remember being told about those matters in Mrs. Miser's evidence. But as I understand it, there wasn't evidence from any trainers of that sort of problem. But
we're going to come to...
No, please, I need to be refreshed by looking at my memory to be refreshed by looking at the documents.
Other than Mrs. Miser's case, did the post office reveal to you evidence that met your objective test, i.e., which proved by means other than the word of the sub-postmaster themselves?
Well, what I discovered was the Calendar Square problem, which I discovered from reading the judgment, but I knew that needed to be further investigated. So that was a piece of objective evidence, precisely the sort of thing I was looking for.
And were you aware that sub-postmasters made complaints about errors in Horizon that weren't investigated, and therefore the availability of so-called objective evidence would never arise?
Well, I would have been aware of that as a theoretical possibility. All I'd done so far, following the steps I've been asked to do, was to bring the Computer Weekly article to the attention of the post office and ask to see the civil files. I did that for 2 days, and I found the Calendar Square problem. It may be that I should be given more evidence about other matters on those 2 visits. But that's what I was trying to do, to find objective evidence. Because it did seem to me that simple complaints were going to be inadmissible and wouldn't assist any party.
What about lines of inquiry that it might allow the defence to pursue?
Oh yes, well it depends on. I have to. What I needed to do was to see the details of the complaints. That's why, and the details were not there in the Computer Weekly article. That's why I wanted to look at civil files to see if I could find more details. More details might lead to an inquiry which would give that objective piece of evidence.
Were you aware at this time when you attended and spent, I think it was a day, is that right?
2 days.
2 days.
And separated as well by a period of time. So that gave an opportunity to reflect on the part of the civil department if there was anything that I hadn't been shown.
At this time, when you conducted the 2-day visit to post office offices, Were you aware of something called the Horizon Help Desk?
Oh yes, well that was part of the evidence in our case, and I was aware of it from other cases as well, I think.
Were you aware of other levels of support available? Something
Yes, I
called
think so, yes.
SSC,
Yes?
sorry, the SCC.
Yes, I'm not very good on remembering what these stand for, but I think I was aware,
You
yes.
were aware of other tiers of support.
Yes, yes.
Were you shown any records within those computer databases of complaints by other sub-postmasters?
No. And I'm not sure, I didn't think of that inquiry, so maybe partly the fault is mine, but I don't think, what I was shown were files that related to the particular complaints, and all I could see within those files were the fact that a complaint had been made, but there may not, there was no evidence to support it one way or another. Sometimes there wasn't a requirement for the money to be paid back, but I was rather frustrated, quite frankly, for my 2 visits, but because I didn't really have very much information, apart from the calendar square, which I needed to investigate.
You say that the test that you had in mind, is there, rewording it a little bit, objective evidence that is capable of casting a doubt on the reliability of Horizon?
Yes.
You discussed that with the defendant's legal representatives when you met in the post office. Was that with Mr. Hadrell from Chambers?
Yes, I think he was there, and I discussed it with him on other occasions in the event. I think I first raised it on the visit to West Byfleet, and I think Mr. Hadrell and Izzy Hogg were present then, I think. I'm not absolutely sure of that.
And they agreed with the test, you say?
Oh, yes. I thought it very important to discuss it together because they might have useful additions to the test I was considering.
And so you were looking for evidence where it had already been established that Horizon, in some respect or other, was lacking in reliability?
Yes, that was absolutely key.
Not mere complaints, no matter whether they came from tens, hundreds or thousands of sub-postmasters?
No, because it seemed to be a complaint was simply a complaint. It wasn't actually, I would see it would be difficult actually to be admissible in a trial.
What about the point that I've made about it might put the defence on a train of inquiry?
Well,
Rather than testing, applying a test for disclosure of whether the product of disclosure would ultimately be admissible.
no, I agree with that. That's part of the disclosure exercise to put the defence on a route to inquiry. But they had a series of complaints. They were well aware of the complaints in Computer Weekly, and I think were brought up to speed about other complaints as and when they arose. I knew that they were being proactive there in a very sensible way. But I was just trying to find something that went just slightly beyond the fact of a complaint, because a complaint can be genuine or it can be an excuse for inappropriate behaviour.
Can we move on? You say in paragraph 5, the only material that should be disclosed is the judgment in the Castleton case. I attach a copy of the final judgment to this advice. All the other material simply contains unsubstantiated claims by sub-postmasters. When these claims have been investigated, no supporting evidence has been found.
Yes.
You say in paragraph 6, you would wish some further inquiries to be made from Fujitsu. Paragraph 23 of Castleton refers to the evidence of Anne Chambers, a systems specialist employed by Fujitsu. When she was cross-examined, she appears to have had full knowledge of an error in Horizon that had occurred at Calendar Square in Falkirk. This is case study 6, seemingly in Computer Weekly. I've seen some civil paperwork in relation to Alan Brown, but not concerning a Horizon error. I don't know if Anne Chambers still works for Fujitsu, but it should be relatively straightforward for Fujitsu to provide full information about what appears to have been a well-known problem at Calendar Square. At this time, did anyone in the post office tell you about something known as a known error log?
I don't remember.
By the time of the trial next year, the following year, by October 2010, had you been told by either Fujitsu, through Mr. Jenkins or otherwise, or by the post office, of a species of document called a known error log?
I don't think so. I don't think the title means anything to me that I can think of at the moment.
A document that records Fujitsu's own assessment of there being an error in Horizon, either in hardware, in coding, in communication.
No. That's the sort of thing I set out in my advice. I'd like the sort of thing I might hope to get, but I wasn't aware of anything like that.
That's precisely the thing you'd be looking for, a recognition by Fujitsu itself.
Oh, that would be the best evidence of all.
So far as you can recall now, did anyone mention the word KEL or known error log at any time in your
I
instruction?
don't think so, no.
That can come down, thank you. We've heard evidence that from Mr. Atkinson that every part of the post office was subject to a duty to record and retain evidence potentially relevant to the conduct of prosecutions. Did you ever advise the post office to conduct a disclosure exercise itself as to what records it held in relation to any problems or issues with Horizon?
No, I didn't ask the post office. I thought the inquiry should be made to Fujitsu. But you're right. It's a sensible inquiry. I didn't think of that.
Why did you limit the exercise to looking at the case papers that happened to be identified in a Computer Weekly article?
Well, I didn't limit them to that. That was my starting point. I've made it absolutely clear, and my advice is very clear on this, that I needed to have disclosure of any problems relating to the reliability of the Horizon system. That is what I make very clear I need in that advice, and I made it clear in all my dealings with those instructing me. They're well aware of that. From all I can tell, the criminal law department were trying to achieve that end as well. But everybody knew, and you asked me earlier about whether this was a test case, and I said it was an important case. I assumed, and it was a very obvious assumption, that people much higher than I would ever come across in the post office and Fujitsu knew about the case, knew about the pieces of disclosure. I wanted to see if they existed. And I assumed I had set in process something that should have readily brought forth important pieces of disclosure. And because nothing came forward, I assumed that the calendar square was the problem.
Why not ask the actual party that is prosecuting, which itself is subject to the disclosure obligations, for any documents that it holds, or to conduct a disclosure exercise to identify any documents that it holds in relation to problems or issues with Horizon?
Well, I thought that was implicit in my general advice. I'd been rather vague about matters, I suppose, but deliberately so to ensure that we could capture the net could be spread wide.
Can we go back to your advice then to look at the focus on Fujitsu, poll 304 4557? And page 3, please. Paragraph 7, you say, I also think that our disclosure duty requires us to ask Fujitsu whether they are aware of any other Horizon error that has been found at any sub-post office. I anticipate that there will be none, but it's important that the check is made. I think you've acknowledged in answer to a question I asked a couple of questions ago, that you think on reflection you were in error in focusing on only Fujitsu, and that you ought to have asked the Post Office to look in its own depositories for any records of problems or issues with Horizon?
Yes, I should have said I think it requires us to ask Fujitsu and consider within the Post Office whether anybody is aware of any Horizon error. That would be a better way to formulate it. I did assume that this, I did draft this very widely. I assumed, perhaps wrongly, that if Fujitsu would be well aware of something that was with the Post Office is well aware of. It's a joint system, as it were.
On what evidential platform did you say you anticipate that there will be none, but it's important that a check is made?
Because nobody had ever told me about anything. I'd found the one piece of objective evidence on my own, and nobody told me about anything else. And I mean, I've said elsewhere that I was aware of the danger of the robust term being a mantra. It needed to be justified. But I was given quite clear confidence from all I spoke to that there wasn't a problem with Horizon. I thought I'd found a one-off problem at Callender Square. That's why I thought I'd found nothing at the Civil Department. And that was the impression I had from having conversations with Mandy Talbot at the Civil Department. I can't remember those exact conversations. My understanding was that this was the only thing. And I think I was the one who found it. I'm not sure she brought it to my attention. I found it within the judgment. And it was striking to me that Gareth Jenkins wasn't familiar with this problem. He needed to research it himself. All this met together to suggest that this was a good system. I'd found something that needed to be investigated. I acknowledged that any computer system can have lots of glitches. That's perfectly possible, and they can arise at future dates as well. But this was how I thought the process was working well.
Can we go forward to page 9, please? Paragraphs 25 and 26, under the heading Other Matters, you say, Mr. Longman has sensibly suggested that the defence expert might want to meet with one or more representatives from Fujitsu to discuss technical issues and reach as much agreement as possible. This is an obvious way of avoiding much wasted time, and such an invitation should be given to the defence. Gareth Jenkins at Fujitsu has provided Mr. Longman with a number of comments about the defence second interim report, which confirm my suspicion that the theory that Horizon cannot deal with refused credit card transactions is simply wrong. He suggested in his comments there are also a number of areas where the Post Office could provide assistance. It seems it would be relatively easy to disprove the theories of the second report by witness statements from Mr. Jenkins and a suitable witness from the Post Office. Those statements should be sought now. Although the defence are likely to come up with other theories, it will hopefully save time and expense of both sides if we try to rebut false theories as and when they arise. Would you agree that still at this stage, this was not advice that treated Gareth Jenkins as an expert witness?
Oh yes, I was using him as a way of responding to the disclosure requests.
Despite the fact you were advising that Mr. Jenkins replied to a defence expert report?
Well, because I saw him as a witness, and I thought it important that it was set out in writing so he could be cross-examined on any answers. I didn't see him as an expert witness at that time, although albeit I appreciated he had considerable expertise.
Can you explain why you did not appear to consider that any statement from Mr. Jenkins replying to an expert report would itself be expert evidence?
Oh, well, if there was a statement by John Longman in reply, that wouldn't be expert evidence either. I saw him as a witness of fact at this stage, but as an employee of Fujitsu. He could give factual answers to inform Professor McLaughlin, who needed information about Horizon. That's what the professor needed. He had hypotheses, but he had no idea whether they were relevant to Horizon. That's why I thought Mr. Jenkins could help, not as a witness, an expert witness necessarily at that stage, but a witness providing facts from his knowledge as an employee of Fujitsu.
And is that what happened, that Mr. Jenkins only provided facts?
Well, then it becomes
Video-
muddled. I would have to see see what's being provided. I can't remember every single statement and every line of it, but it becomes muddled, and I can see that, I'm sure.
Can we turn back to the chronology, please? FUJ 0015 2887. And look at page 2, please. At the foot. And keep going, thank you. And a little bit more. Thank you. This is a continuation of the email trail that we were looking at before the excursion into your advice. And so before we examine what happened as a result of your advice, let's just track back to see what happened following the administrative arrangements being discussed between Jane Owen and Penny Thomas. At the foot of the page is an email from Penny Thomas to Jane Owen. I hope all is well with you. Our expert, Gareth Jenkins, has made comments on the second interim technical experts report, which I attach for review by prosecution counsel. Please note that where the post office is required to respond, he stated so in the text. We agree that in the new year we would discuss how this would be presented. Mr. Jenkins is here being referred to as an expert, which of course may mean either a person with expertise or a person who qualifies as an expert witness in legal proceedings. At this point, what was your understanding of Mr. Jenkins' status?
Well, I didn't understand him to be an expert witness yesterday yet. I thought he was answering disclosure requests through his expertise. But I can see how it's becoming blurred. That's the trouble, and I acknowledge that.
And then page 1, please. An email from Mr. Longman to Penny Thomas of the 27th of January. Our defence barrister has asked for all of Gareth's replies in relation to the defence's second interim report to be produced as a witness statement. I would suggest that the question from the defence is reproduced and then Gareth's replies are recorded immediately after for clarity purposes. And then the second paragraph is not relevant. That is reflecting what you had advised, isn't it?
Yes.
And again, at this stage, it wasn't suggested, I think, in this email train that Mr. Jenkins was being treated as an expert witness.
Yes, that's right.
Would you agree that so far the requests made to Fujitsu did not constitute the proper instruction of Gareth Jenkins as an expert witness?
Yes.
Can we move on, please? Fujitsu 0015 2902. We're moving on to the second page, please. 1st of February 2010, and over the next 5 or 6 days, there's quite a bunch of emails that we're going to have to go through before lunch. 1st of February 2010, Mr. Longman, the investigator, to Penny Thomas at Fujitsu. Penny, at a pre-court hearing today, the judge ordered that all the defence requests for further information be answered by Monday, the 8th of February, so that's a 7-day order. Our solicitor in the case has asked that Gareth's statement is completed by Wednesday so that he and our barrister can examine the statement. Gareth's statement needs to cover the following 4 points. 1, our defence barrister, I think that's you.
Yes, that is it's a typo, isn't it?
Yeah. Has asked for all of Gareth's replies in relation to the defence's second interim report to be produced as a witness statement, and then the repetition of what we've seen already. 2, my barrister, I think that's you again, telephoned me yesterday evening and requested that I find out any information that Fujitsu may hold in relation to an office called Calendar Square in Falkirk. Apparently, Anne Chambers is a systems specialist employed by Fujitsu, who was cross-examined. It said that she had full knowledge of the error in the Horizon system at this post office. 3, when Gareth completes his statement, he could also mention whether there are any known problems with the Horizon system that Fujitsu are aware of. If none, could this be clarified in the statement? That's a reflection, I think, of paragraph 7 of your advice, isn't it?
Yes.
And then could Gareth read the statement for Eleanor Nixon attached below? In addition, our barrister would like to speak to Gareth directly and would be grateful if in the first instance, whether Gareth could either send him his contact details or give him a call on his mobile, and then details are given. So, paragraph 2, request to find out information in relation to Callender Square in Falkirk and the issues with Horizon that arose there. That arose as a result of reading the judgment of His Honour Judge Havery.
Yes.
Disclosure about any known errors in Horizon. It is translated into Gareth completes his statement. Can he please mention whether there are any known problems? The request that you'd made was slightly different to that, wasn't it?
Yes, it's
been watered down.
It's watered. Well, yes, and it's unfortunate that, because if it had remained at Fujitsu, we may have perhaps got some more answers. I don't know.
Unfortunate, why?
Well, it shouldn't just be for Gareth Jenkins, and I think I should have pressed on that requirement in paragraph 7 of the advice. I think it's now become Gareth Jenkins is going to deal with it. It has been watered down. That's an appropriate phrase, and it's watering down what I wanted, and that was wrong.
So it's gone. Would this be the fair characterisation of it? From asking for a disclosure exercise to be undertaken by a third-party provider of the computer system of any known problems or issues with Horizon, which would be a proper request to a third party, to one man mentioning in a witness statement if there are any known problems.
Yes, but I still expected to be told, because Fujitsu and the post office were aware of this case, were aware of what I wanted, and I expected to be told if there was a problem. As I understand it, well, I don't pretend to fully understand all the problems that have been identified. There was plenty that should have been disclosed, and it wasn't forthcoming. So I assumed that it wasn't there to be given. So in a way, I would have, if I'd thought about this being watered down, I wouldn't have seen the danger, because I assumed that those who had information, who knew about the case, would do what had been requested of them.
Can we turn to poll 305, 4085? And look at the second page, please. This looks like it was meant to be an email to you because of the salutation, John L. / Warwick, but I can't see that it's sent to you.
Yes, I don't think it was, no.
In any event, Mr. Longman says to Mr. Singh, I've spoken to Penny Thomas and she has arranged for a meeting to be held today to discuss the statement we require from them. After that meeting, she'll then be in a position to confirm the timescales involved and the cost to the post office for the statement. An authority to proceed will then need to be authorised. She's aware of the deadlines. So it seems that there was then to be a meeting between the post office, including Mr. Longman, and Penny Thomas on behalf of Fujitsu, concerning the nature of the statement that was required from Fujitsu.
Yes.
Can we turn, please, to UKGI 001 4895? UKGI 001 4895. Thank you. We can see that this is an email from the Defence Solicitor Easy Hogg to John L. Singh, copied to her counsel Keith Hadrill, and copied to you, dated the 3rd of February still. And in the 5th paragraph, if we scroll down a little bit, the one beginning "you have," it states you've indicated you do not you do not propose to rely on an expert, but on the employees of Fujitsu. For the first time at the hearing on the 1st of February 2010, you identified that witness as an employee named Jenkins. However, not only have you not served his evidence prior to suggesting a meeting, you accept that you haven't even taken a statement. At this point, does that characterisation by the defence accurately reflect the position that Mr. Jenkins was neither instructed nor regarded as an expert by the prosecution?
Yes, and it ties in later with what they said at the abuse of process argument, that the expert hadn't been properly instructed, which is a very valid criticism. And perhaps I didn't take it on board and think it through as much as I should have done.
Can we move on to a couple of days later? The series of emails exchanged between the Post Office and Fujitsu on the 5th of February 2010 in relation to the provision of a witness statement from Mr. Jenkins. Can we start, please, at FUJ 0012 2713? And if we start at the very bottom of the page and go over to the next page, we'll see an email of the 5th of February at 12:34 from John L. Singh to David Jones. He's a lawyer in Fujitsu, David Jones, asking if Mr. Jenkins could give a witness statement in the Misra case once he returned from leave. I refer to our conversations of the 4th and 5th of February with regards to the obtaining of a witness statement of the defence challenging the reliability of Horizon. I understand that Mr. Jenkins has been identified as an experienced person to give this statement. I'd be grateful if you could confirm to me when he'll be available, essentially. So Mr. Singh into a lawyer in Fujitsu. And then scroll up to the first page, please. And keep going. And keep going. Mr. Jones's reply to Mr. Singh, copying in Mr. Jenkins and Penny Thomas. Thank you for your email, which I've now received. I met this morning with Mr. Jenkins, who came into the office briefly to meet with me. Gareth will help with this matter. He should be back to normal working next week. His input will be coordinated by Penny, who's responsible for delivery to the Post Office of support in the security area. Attached is a first draft of a statement from Gareth. I'd like you to review it and indicate if it answers the questions in the detail you require. There are some areas where Fujitsu cannot deal with the defendant's expert's criticism, as they are about post office procedures or requirements, and it seems evident there will need to be a post office internal expert who can work with Gareth to deal with these areas. So they continue, one concern is that the Post Office have not apparently requested transaction data for West Byfleet for the period and transactions in question. This would normally be provided in previous cases and would include Fujitsu extracting log files from the system to enable us to provide details of transactions. Surprisingly, this has not been requested in this case. Perhaps you would consider the need for this. At this point in time, you're not a copyee of this chain at the moment. Did you understand the problem with asking a person with expertise, Mr. Jenkins, to comment on what the defence expert was saying without having requested transaction data for this branch?
No, I didn't realise that was, or fully realise that was a problem. I thought he'd be able to deal at least in part with answering the questions, particularly to deal with the questions that were based on a misunderstanding.
Can we go, please, to poll 0002 9369? Can we look, please, at page 2 and scroll down? I think this is the first time that the statement emerges. At 2:53, an email to you and Mr. Longman. Dear John and Warwick, herewith statement from Gareth Jenkins, just off the press. Please let me have your comments on whether this is adequate for our purpose, or does it require additions before being served on the defence? So John L. is asking the investigator and you as prosecution counsel whether the statement is adequate and for your comments. And if we go to page 1, please, at the foot of the page, we see Mr. Longman's reply. John L. Points 2 to 4 have not been answered, and he reproduces them below. My barrister telephoned me yesterday evening and requested I find out any information that Fujitsu may hold in relation to Calendar Square, etc. Do you remember that? 3, when Gareth completes his statement, could he also mention whether there are any known problems with the Horizon system that Fujitsu are aware of? So that's the watered down, if I can call it that, requirement emanating from paragraph 7 of your advice.
Yes.
And then over the page, please. If none, could this be clarified? 4, could Gareth read the statement from Eleanor Nixon, etc.? So Mr. Longman is saying points 2 to 4 have just not been addressed by Mr. Jenkins. Yes?
Yes.
Go back to page 1, please. You reply the following morning at 7:07. Can you see that?
Yes.
You only reply to Mr. Singh, taking Mr. Longman out of the copy list. And you say, Mr. Longman sets out in his email the extra matters I asked Mr. Jenkins to look at. In relation to the Eleanor Nixon statement, Mr. Jenkins should also be made aware of the information we recently received, etc. The areas where Mr. Jenkins says for Post Office to respond should be deleted from the statement. These areas will only lead to a flood of further disclosure requests. I'm afraid that the post office will never respond. Why were you suggesting that where Mr. Jenkins was saying this is not something I can respond to, it's a matter for a post office to respond to, should be deleted?
Well, it didn't seem to me to be part of his witness statement, but I think I was simply frustrated at the various delays there had been that were causing so much problems with the chronology of the case in trying to get it towards a trial.
Wasn't that important information or relevant information that the experts felt, or the person with expertise felt unable to answer a question and said, this is for the post office to reply?
Well, yes, but the inquiry had already been made, and I'd have to look at the document because I can't remember exactly what the inquiries were, but I'm afraid it all comes out of a generally very frustrating situation where there are an enormous amount of disclosure requests that it's proving very difficult to respond to. I was just trying to limit them because it was out of control, and efforts that I had made to try and put it under control had failed.
Why did you think the post office would never respond?
Well, I think those are heated words that perhaps aren't fully thought through, but I was frustrated that it was taking so long, and frustrated that I was being told that essentially the investigation team was going to be clogged up completely for an indefinite period while efforts were made to respond to requests. At the same time, I have judges at Guildford Crown Court making very strict requirements for progress to be made, and it's a very frustrating situation generally, and I'm expressing the frustration, I suppose.
Does it follow from that although you advised that the sections of the witness statement where Mr. Jenkins had said post office should respond should be deleted, you didn't give any advice to the post office that it should meet its disclosure obligations in relation to them?
No, I should have done that. And I was finding this all very stressful, and that's a symptom of it, and it's my fault, but this was difficult.
So that's a convenient moment to break, bearing in mind that we took an early break and it was short, and we haven't taken a second break. And I've done that deliberately in order that we can get through all of the business that we need to today. I wonder whether you might break until maybe 25 to 2?
Yeah, by all means. So I'll see you all at 25 to 2.
Thank you very much, sir.